Hello, everybody. Richard Tromans here again at Artificial Lawyer TV. Today, we're exploring the challenges faced by large commercial law firms when handling litigation, particularly commercial litigation, in an environment where most people are still working remotely, where many courts are operating remotely as well. And there's all kinds of technological and human challenges to getting the results that you need for your clients. Joining us to help explain some of the challenges and some of the opportunities is Melina at Eversheds Sutherland, the global law firm. And Melina works, in fact, she heads up the litigation technology group at Eversheds. Glad to have you on the show.
Thank you very much, Richard. Hello, everybody. Hello from me as well.
Maybe just to start off with, just very briefly, what does your role actually entail?
Of course. So the litigation technology department in Eversheds Sutherland deals with electronic discovery and also electronic bundling, trial preparation, virtual hearings, and the latest addition to the team being legal project management. So it's a variety and a range of services from end to end. We've got obviously all the services in-house, and yeah, that's essentially what we do.
Gotcha. And you are a trained lawyer yourself, although you're not practicing.
I am indeed. Yes, I used to practice as a criminal defense solicitor, specializing in serious fraud. No longer practicing, but still a lawyer at heart.
Gotcha. And Eversheds, as I'm sure a lot of people know, he does a lot of disputes, does a lot of litigation. It's a major practice at the firm, isn't it?
Absolutely, yes. I think in the UK alone, we must have like close to 1,000 lawyers working, obviously, in the litigation practice.
Yeah.
I hope I haven't messed the numbers too much anyway. We are incredibly busy, always have been, and in the latest circumstances, even more, if I may say so. Yes, so for us, I think litigation technology was a rather organic move, if you'd like, quite forward thinking, as it was well before my arrival under the Eversheds Sutherland umbrella, but still very much necessary.
Gotcha. So yeah, I mean, if you've got 1,000 lawyers in the UK doing disputes and many others in all your offices around the world, I mean, you must be handling literally dozens of cases simultaneously. Many of these are now remote. So let's get into that. So how has it been? I mean, a lot has been said about the wonders of remote courts and how wonderful it all is, and I'm sure there are some positives, many positives. But I guess there's been a few challenges too. I mean, how have you managed to do this?
I mean, absolutely. No change comes with just positive. There's always like lessons learned and challenges that we have faced. I mean, I would say there was a rather rapid change, and being perfectly honest, there was a mentality shift that was in the making for years, and then it took a pandemic for the lawyers to very, very quickly shift from a rather paper-bound mentality to everything completely digital. You were talking from shifting from an office obviously set up to a fully remote setup, all the meetings becoming fully virtual, everything being shared across collaboration channels between legal teams and also the legal teams counsel and the clients. And of course, as you briefly mentioned, virtual hearings. So court hearings were no longer viable, were no longer a feasible option, and everything switched into what we call remote/virtual hearings.
Gotcha. And I guess, and you know way more about this than I do, but I guess from a layman's perspective, there's three key elements to this, which is first of all, you've got the actual virtual hearings and meetings on the sides of those hearings, I guess, between the lawyers and the different parties, witness statements, all that kind of stuff. Second leg, I guess, is the things around e-discovery and document review. And the great mass of work that goes into understanding what's in all the evidence. And then I guess the third bit is, you might say, the infrastructure, systems that allow you to keep track of cases, to move all those documents around, to make sure that everyone's got the right reading materials and so forth. I mean, is that basically it? Is mainly those three legs, or is there other stuff that's going on?
I mean, I would think you captured let's just call it the dominant factors and the main three legs that we have had to face during this period of time. Data collections and everything being remote, I think it would, let's say, be caught potentially under the infrastructure leg, but it became a massive shift and a massive piece of new work for everybody as well. If I was to walk through the three legs that you just described, obviously from a remote hearings perspective and all of the setup, you're talking about multiple different scenarios. You could have a full-blown virtual hearing, which could be facilitated with obviously video conferencing, live transcripts, electronic evidence, electronic bundles that have been prepared and collaborated upon way before the actual virtual hearing. There is a lot of logistics to go behind this, from the ideally collaborating and working from one central bundle across multi-party use. You are talking also about which pieces of software are you going to use. The feedback that I have got, or that I've had to provide guidance on, let's just say, when people come to us for virtual hearings, has been that every experience that had to be segregated, you potentially use one piece of software for the video conferencing, another piece of software for the bundling, et cetera, has not really been as seamless or as smooth as it would have been desired. So ideally, you try to put everything under one umbrella, as then you have obviously the central coordination of that. I mean, in Eversheds, I think we were absolutely blessed, if that's not too dramatic of a word, because we did have already electronic bundling and trial preparation software in-house. So we were doing this to the greater extent anyway. We've got a fully known, fully advertised collaboration with Opus 2. And then as soon as COVID obviously started, Opus 2 provided full virtual hearings support that came with all the elements that I outlined earlier to you. And then once basically all the parties would be in contractual agreement with that, there came all the coordination from Opus, the technical setup, the technical testing that needs to take place as well to make sure that everything works from all potential locations that parties are, joining the virtual hearing from. And, you also mentioned different meetings, different conferences, and I wanted to spend just 30 more seconds, because if the main challenges, and I think that the key lessons learned immediately came from that aspect, the whole privacy of conversations, and are you actually even speaking in the chat that you think you're in, or are you talking on a chat and other parties that are not supposed to be hearing you can actually hear what you are talking about? So of course, you've got pieces of software along the likes of Zoom that we are currently recording in that provide this, as it calls it, breakout rooms, so they can be set up and can be made available. So as a virtual hearing is going on, counsel and the client can confer on the side while still potentially just being present, in the greater trial, and then go back into the greater hearing. But even when pieces of software that don't allow that have been utilized along the lines of Skype, for example, then you needed to make sure that any side conversations and any private conferences would be facilitated through different pieces of software, including even also picking up the phone, if anybody remembers that, and actually having a conversation over the phone.
Well, it's an interesting point, isn't it? I mean, have you had situations where, I don't know, Mrs. Smith from Tunbridge Wells thinks that she's, talking to her chiropractor, and then suddenly, you find her in the middle of this court case, or perhaps more likely, someone involved in the court case doesn't realize that their supposedly private conversation isn't actually very private, and there's a whole bunch of other people listening.
Absolutely. I mean, I would say, fingers crossed to this day, and knock on wood, we haven't had any mishaps with the virtual hearings and the general hearings that we have accommodated. But as parties, our own legal teams and even client parties have come to us inquiring about those scenarios. I mean, they've been highly publicized, unfortunate incidents out there. But also we have heard about other hearings that they were part of, so not hosted by Eversheds Sutherland, and people have dialed in the wrong meetings, or they thought that essentially they could not be heard because they muted themselves, but actually the piece of software hadn't allowed for them to be muted. So although they thought they were having a private conversation on the side over the phone with, let's say, their barrister, actually it was not happening. And we also did get the ever so amusing story, not so amusing obviously for the parties involved, that there was a case that we were actually handling as Eversheds Sutherland from a legal standpoint, and the key witness took the stand and was about to offer, let's just call it, the hot piece of evidence. And as he's about to open the mouth and speak, everything absolutely froze. The witness, of course, carried on talking. All the parties were frantically trying to figure out what is happening. And until the time that essentially the network, allowed for him to resume, the evidence had been given. So there needed to be, obviously, you understand, an interval, like further arrangements to be made. So there can be circumstances that, of course, it's far from ideal, and nothing can actually replace the physical presence,
No.
even from a control standpoint, even from the judge.
Well, we'll come to that. Well, judges was the next question I was going to ask you. Some judges are very, very, very good at tech, and I've met several who've actually been driving innovation inside the Ministry of Justice, for example, and done great work. Many others are not, perhaps, quite as advanced. Have they been able to handle this? Because, there's a lot of stuff going on, isn't there? Aside from all the video conferencing and private rooms and the confidential stuff going on here, confidential stuff going on there. There's a lot of potential matters that could actually undermine the case if mishandled accidentally. A lawyer could stand up and just say, "Well, look, actually, someone's heard a piece of information they shouldn't. This case is over." Quite serious stuff. Are the judges? Are they receiving training? Does Eversheds kind of help them, or I guess maybe you're not allowed to? I don't know. Who's helping the judges?
So it depends on the technology and essentially the contractual agreement that is applicable to the particular hearing. For example, if we were to talk about a full-blown virtual hearing that, as I mentioned, is facilitated through us and Opus 2, they would, of course, receive full training. They get testing rounds. They get absolutely everything. I would say to you, if I may say that, the superheroes of the day are actually the clerks, believe it or not, as they are the ones tasked with all the coordination of Skype, the digital evidence, the digital bundles, the navigation. Before lockdown, I was lucky enough to be present into a fully digitized trial, but with everybody in court. And it actually astounded me how tech savvy the clerk was navigating through all the pieces of software. Granted, they had been given prior training, as I mentioned, by Opus 2 and ourselves, but it was they were pretty much the puppet masters, if you'd like, in the court.
That's the clerk of the court. We're not talking about the barrister's clerks. This is the clerk of
the clerk of the actual court. Yes. So even in virtual hearings, which would pretty much mimic the same thing, albeit with virtual, presence, it would still be the clerk of the court. Gaining control of a lot of those things. Judges they've been quite eager to embrace the technology. I would say to you, a little bit of a shift is always expected. You see it from lawyers to judges all the way, a little bit of reservation, which, doesn't surprise me at all. And surprisingly enough, I think, not in litigation cases per se, but more in the likes of arbitration cases, because the virtual element, due to different jurisdictions and elements and witnesses that had to be, partaking in the particular arbitration cases, they had moved to the virtual element earlier. And it is actually those arbitrators / judges, as I'll obviously call them, that have been the more tech savvy and followed the path of least resistance, if you'd like, with these pieces of software.
No, that makes a lot of sense. And just to recap and just to clarify, so Opus 2, which, if people don't know, is a technology vendor, which helps with bundling and digital sharing of information and documents and so forth, they are actually getting involved in training the judges.
They can provide training to basically all parties of the virtual hearing. So yes, they could be training them.
So it's not the Ministry of Justice that's training the judges. It's actually the tech vendor.
I would think it is, being perfectly honest with you. I don't know that for 100%, but every piece of service that I've seen being bundled and being offered out there, and given how they're fully responsible with the tech setup and the familiarization with the software, I absolutely think that they would be you know, if not responsible, let's just say willing to provide training. And of course, we do that ourselves as well. I mean, not to the judges per se. I don't think we actually to this day have trained the judge, but we have trained, you know, barristers, obviously, for the use of the
Yeah.
technology.
No, it's just fascinating, to see effectively the tech company not just providing the tech, but literally getting right in there into, effectively updating the way a court runs.
Mm,
It's fascinating. Let's move in a sort of very different direction. So digitization removes friction, it speeds things.
mm-hmm.
If managed well, it reduces all kinds of problems. Does it also reduce the cost to the law firms and the barristers of running this case? Because you don't have to travel to the court. There's far less wasted time in general. Does it actually have an economic benefit?
It does indeed. I mean, I would say again, from gathered feedback from myself and the greater team, the the budgeting perspective and the whole projection of costs, as soon as you eliminate traveling costs and even including time that somebody has to stay in court waiting for them to be called to give evidence or something along those lines, has been massive. And it's a great benefit. And again, it's been something that has always, I've seen lately being raised as a massive advantage when one was to question the lack of physical element and the lack of physical presence in court, and how much of a bias does that introduce. So you always get like the balance scales, like between the costs and obviously the physical element, and
Mm.
how much of a benefit would that actually give us. So yes, undoubtedly the costs have been reduced. I mean, I would say that overall, anything that is controlled by technology allows you more and more proactivity and allows you multiple technical setup and technical test rounds, so you can make sure that everything will go as smoothly as possible on the particular day, and everything, as of course, like I said, is basically held and controlled in a central repository of information. So it for me, the greatest enhancement is collaboration. It
Mm.
forces all parties to share and collaborate more closely on all materials versus expecting the multiple paper bundles to be couriered across to you and not having the latest editions or the latest annotations that Richard applied, have them at the tips of your fingers
Well,
within essentially 3 minutes.
I mean, that's an interesting point, isn't it? I mean, do you think that the actual quality of the cases is improving? Because, I mean, one of the challenges, and of course, judges and barristers and solicitors obviously don't want to talk about it too much, but they have so much information to handle, particularly when they're reading paper documents. It's
Mm-hmm.
inevitable that they miss stuff, that stuff gets lost. Even barristers with the most photographic of memories will not always be able to, you know, reproduce in the moment what they need to. Um, Presumably, with it being digitized, you can focus and drill into the important information and find it much
Mm-hmm.
more rapidly, which then produces a better court case for all involved, because you're not leaving important information aside.
Mm-hmm.
To put it very simply, you don't have so much you don't have so many paper documents that you forget stuff.
Absolutely, absolutely. I would say even the most reluctant of the minds that I had the pleasure to speak to have
Mm.
shifted quite quickly. When you start describing the unique features of technology and everything becoming digitized, from key terms and key entities being pre-highlighted for them so their eye gets immediately drawn to the key facts of the case, from them being able to annotate and highlight exactly as they would use the multiple multicolored highlighters that they would have at their desks, and also features such as hyperlinking exhibits. So they're in the process of drafting numerous witness statements, the legal teams that is, they go back and forth with the barristers and what have you. They start linking exhibits with the uses of software such as the software that we've got in-house, Case Ready, that is it becomes so easy for them to hyperlink. So then your electronic bundles are far more intuitive, and in my humble view anyway, they are far superior to what any paper bundle could potentially offer to you.
Yeah, no, absolutely. I get. I mean, to put it very simply, again, it's the difference between the Encyclopedia Britannica and Google and Wikipedia.
Yeah,
I mean, one obviously is, if you read the entire thing, would be more comprehensive, but at the end of the day, you just don't have the time, realistically, in many cases. Let's just, and I guess also, I was just penultimate point, which is I imagine that aside from erasing the need to wait around in court, the overall court case itself should be faster because there's less of this kind of, and my lord will be will turn to, folder 3, paragraph, whatever, because you can just zap to it.
Mm-hmm. 100%, 100%. I've seen, and again, the reason I say that is because when lockdown was imposed and everything all of a sudden changed, everything was meant to be a physical hearing. So when we were requested to project them as virtual hearings, and obviously quotes needed to be generated, etc., I could see that some 12-day hearings, for example, that were meant to be, all of a sudden were turning into 6-day hearings or 8-day hearings due to the very, very succinct arrangement and coordination of particular elements. You no longer have delays of witnesses showing up. Everybody knows exactly the allocated slots they will have. Everybody's working, as I mentioned, from a fully digitized copy. Will you have technical glitches? 100%. Everybody's relying on their personal broadband as well, so it can get quite tricky. The software can, break down as everything technological, from our phones to everything. So of course you will have those faux pas, whether you like it or not. But I think overall, time efficiency and cost efficiency are two undeniable benefits of turning to a fully digitized era.
Awesome. Well, last question, and this is probably the hardest question, which is, there's clearly lots of benefits, and you've explained that very well.
Mm-hmm.
I guess also there could be some challenges in that even in a commercial civil case, the defendants, you could argue, is going to be slightly disadvantaged, not because the evidence will be unduly against them, because that won't necessarily change. It's simply that because they're not in front of the judge, and if there was, for example, a jury, although there won't be many civil cases,
Mm-hmm.
you're losing that personal connection. You're losing that ability to look the judge in the eye, not just through Zoom or through a sort of low resolution camera on your laptop, but literally to stand in front of the judge and just go, look, I didn't do it, Gov. I didn't do it. It's not true. And the judge can actually look at them and go, well,
Yeah.
despite the evidence, their demeanor, their personal presence, it's telling me something, and it does actually slightly sway the way I'm going to rule on this civil case. And obviously, in criminal cases, and
Even more.
it would be a disaster. Personally, I think it would be a disaster to move
Mm-hmm.
to move to virtual hearings. I think get the information moving digitally, but
Mm-hmm.
when you're talking about putting someone in prison, I think you've really got to stand in front of them.
Absolutely. I mean, absolutely. I don't know whether necessarily, yes, that would be classified as a challenge. And I think this is why we're going to see a bigger move towards hybrid hearings that essentially allows the combination of the physical element and the benefits of the digitized element to be, amalgamated in one. Because I would say to you, exactly as you mentioned in criminal cases where facial expressions are a key element when one is giving evidence, or as you mentioned, their life could be at stake or their very, very own fate. But even when I've had a chat in relation to arbitration cases, there started being conversations already. So what will happen even if people are, let's say, in the courtroom, but they have to wear masks because of the rules and what have you? Because again, you're going to lose essentially the element of the facial expression or potentially something. So I still could tell that there's a lot of burden that is tied to that very presence and that how you convey your statements in front of the judge. Absolutely a challenge, 100%. And this is why, and I've already seen a couple of scenarios. We've already provided support in relation to 2 hybrid hearings. And essentially, the judge followed a line of the absolutely essential parties to be in court. And then, for example, if you would have an array of counsel and, of course, the clerks, and then you get principal, associate, and partner, and of course an array of paralegals. So you would get the absolutely critical parties to the case that would need to be in court alongside the judge, and then everybody else that would serve still a great purpose, but let's just call it even maybe a more administrative purpose. They could still attend digitally and of course communicate via Teams, Zoom, or any other platform of choice with the parties in presence and court to communicate notes, comments, and things like that.
Interesting. Yeah. So, well, this brings us to the end, and which I guess just a quick comment on the future. So it looks like whatever happens, things are going to change. That
Mm.
there'll be, even if we go back to having normal court life, that new normal is going to be a hybrid one. There's going to be a lot of digitization. I mean, do you think that things have permanently changed now? That you can't put this genie back in the bottle?
I think so. I think so, but for the greater good, not necessarily, because it's inevitable. I don't. I think, as I said, this shift was very much anticipated by tech geeks such as myself, and we were longing for all parties to move and be completely paper-free and basically move towards the completely digital era. I don't think it's going away anytime soon, and I don't think, in fact, it's going anywhere at all, because as you and I have already discussed, the cost benefit of it all and the massive reduction that you're gaining from there, alongside avoiding delays, expecting somebody to be present on court and for whatever reason, with the latest of notices, they don't show up. Whereas that element of somebody from even a foreign jurisdiction in a foreign country being able to actually dial in and give their evidence is completely, it's undeniable and it's irreplaceable. So yeah, I think it's here to stay.
Fantastic. Thank you, Melina. That's a
Oh, thank
fantastic
you.
overview. Pleasure to have you on the show. I look forward to having you back at some point. So no, thank you very much.
My pleasure, Richard. Thank you for having me. Bye, everybody.